Good morning. It's May 13th, and this is attorney Michael Monheit. And I'm about to review with you a complaint that's been filed in Alameda County, California, with over 50 plaintiffs. This is a claim that's been brought against Gilead. The case is brought against Gilead Sciences Incorporated and any subsidiaries that may later be named. It was filed, as I mentioned, in Alameda County, California. The case number is RG 190-14851. And it's a complaint for damages brought on behalf of around 50 plaintiffs against the manufacturer. And it includes 5 different counts for liability. The first one is negligence. The second one is strict product liability. The third, as I'm reading here, is a breach of express warranties. The fourth count is a breach of implied warranties. And finally, a claim for fraud and concealment. And they demanded a jury trial in the case. So what I'm going to do during this video is walk you through the specific allegations for each count of liability so that you have a better understanding of the types of allegations that have been made by these plaintiffs and what Gilead is being held to account for. Now, in order to understand the factual background of this litigation, I would urge as an introduction to understanding this case that you take a look at our previous video, which is posted both on Facebook and in YouTube. That video will help you have an understanding of what had taken place in the years prior to the release of TAF on the market and what Gilead knew, what they were doing in terms of withholding that product from the market while they continued to market the less safe TDF product. So those allegations are spelled out in much greater detail in our prior video. This complaint that I'm reviewing with you is over 100 pages long, and it sets forth the allegations on behalf of 50 people against Gilead. And as I mentioned, then in 5 separate counts of liability, 5 different theories under which the plaintiffs could and plan to prevail against Gilead. The first count, the first cause of action, is one for negligence. Now, what is negligence? Negligence is a failure of a party to exercise reasonable and due care under the circumstances. And the allegation here is that Gilead had a duty to exercise reasonable care in designing and manufacturing and marketing pharmaceutical products, including TDF-based medications. The manner in which Gilead went about designing, manufacturing, promoting, and distributing the products is the basis of these allegations of negligence. They voluntarily assumed and undertook a legal duty to exercise reasonable care and to comply with the standard of care in designing and manufacturing, marketing, and selling pharmaceutical products, such as these TDF medications. This meant that Gilead had a duty to refrain from selling anything that was unreasonably dangerous and to ensure that the products would not cause harm to patients and to warn patients of any foreseeable risks of harm. Gilead owed these duties to the plaintiffs because it was foreseeable that the plaintiffs would be taking the medications that Gilead supplied and would ingest them and would consequently face any increased risk of harm from these products. And so Gilead's knowledge that these medications were associated with elevated risks of kidney and bone toxicity and the ability to cause injuries resulting from taking these medications and harming the kidneys and bones was something that otherwise these patients wouldn't have been at risk for. Gilead knew before it marketed its first TDF-based medications and every subsequent TDF-based medication that TAF was a safer product than TDF and reduced the risk of kidney and bone toxicity. And as such, Gilead was bound to this duty to act reasonably with the standard of care and in accordance with the knowledge that Gilead had about the safety of TDF relative to the safety of TAF. Despite knowing that TAF would reduce reasonably foreseeable harm to patients' kidneys and bones, Gilead repeatedly incorporated the TDF design into its antiviral medications, and thus it denied patients the opportunity to take a more effective and safer TAF-based medication. And it is alleged that they did this solely in order to maximize financial gain for Gilead. All the more, with thousands of patients experiencing damage to kidneys and bones as a result of unnecessary exposure through the TDF medications, some of this damage which is severe and irreversible, Gilead knew about the likelihood and severity of these injuries to the kidney and the bones suffered by patients like the plaintiffs, and that it far outweighed the burden in taking safety measures to reduce, avoid, or otherwise prevent this harm. The plaintiffs allege that Gilead failed to use a correct amount of care in designing the TDF-based medications that a reasonable and careful manufacturer would have used to avoid exposing patients to the foreseeable risks of harm when taking into account the actual knowledge that TAF was safer and more effective than TDF. As set forth in the complaint, Gilead knew that these products were going to be taken by the plaintiffs. Gilead undertook to develop and market the TDF medications, and they knew that these medications were going to be taken by patients just like the plaintiffs. And they abandoned the TAF design purely for monetary gain and misrepresented why they were abandoning the safer TAF design. Doing this, Gilead failed to exercise reasonable care. And in doing so, in performing this undertaking, they increased the risk of harm to patients and, in fact, directly and proximately caused plaintiffs' injuries. So the allegations make clear that these are acts of negligence that are the basis for holding Gilead responsible. Gilead knew, or reasonably should have known, that the TDF-based medications were dangerous and likely to be used and likely to cause harm, and it was foreseeable that compared to the more effective and safer TAF, much greater damage would be caused. It's alleged that it's negligent for Gilead to have designed the TDF-based medications when they knew that TDF caused harm to patients' kidneys and bones at much higher rates than TAF-based medications, and that they intentionally withheld the safer TAF design from the market, and in so doing acted with reckless disregard and a lack of concern for the rights of the patients, these plaintiffs who are bringing these claims. So the claim for negligence is simple, that as a direct and proximate and legal result of Gilead's recklessness, carelessness, their negligence, a violation of existing standards of care, a failure to show due care to the plaintiffs, that the injuries to these plaintiffs, to those patients that are bringing these claims, was caused. And these injuries that were caused have created a situation where plaintiffs have suffered injuries. Each of the 50 plaintiffs that are listed in the complaint have suffered these injuries and are bringing claims against Gilead for Gilead's negligence. Stay tuned for our next video, which will continue to analyze this complaint, and we'll begin to discuss and review count number 2, the claims for strict liability against Gilead.